we talk about the Chevron decision. Seems to be a bit of concern, confusion about this decision, especially its impact on cybersecurity. Just maybe boil it down for us. Just kind of how do you see it in terms of impact?
The Chevron Doctrine is a canon of statutory interpretation. It's been around for decades. It's been around for 40 years. And it was decided in an environmental case. A lot of administrative laws decided around environmental cases. So this was a Clean Air Act case, I believe, 40 years ago. And what the Supreme Court did at that time was to say there are two steps to interpreting Congress's intent in this environment. The first is to look at the plain language of the text. If that is clear, then that's what happens. Whatever Congress said, if it's plain language, that's what happens. The second step, if it's ambiguous, if you find after that first step that the statutory language is ambiguous, then we defer to the executive department or agency for their interpretation because they are subject matter experts. So the courts for those decades, when a challenge to a statutory decision comes up, they will say, let's look at the plain text. If it's ambiguous, let's defer to however the agency has interpreted. The consequence of overturning Chevron is that agencies no longer have deference. There is no longer deference on how agencies interpret the statute based on their own expertise.
So it basically removes that kind of interpretive power
Yes.
from the agencies. So would that imperil or cause challenges to executive orders or pending legislation? Things like
Not so much executive orders. So what the court said this year was we overturned Chevron because it's not really a canon of statutory interpretation. We have a law that Congress passed a long time ago called the Administrative Procedures Act. And in that law, it gives the judiciary the power to interpret the law, that they are the experts for interpreting the law. This is what Chief Justice Roberts essentially said in overturning Chevron. So that the agencies don't have deference. It's really the courts that interpret the law. So what does that mean? That means now that you have to rely on Congress to be far more prescriptive so that it falls into that plain language bucket. And you have so for Congress to be more prescriptive, Congress has to be well educated on cybersecurity. But it also means that the judiciary has to be well educated on cybersecurity because they are charged with interpreting the law, interpreting what the laws that Congress promulgates. So the consequence is that all the expertise that's been built up over time at the department and agency level in the executive branch, that knowledge and expertise has to be transferred to Congress and the judiciary, and it's incumbent upon all of us to educate all three branches of government as much as possible. But I did want to bring up another case.
Of course.
That Chief Justice Roberts authored as a part of the majority of the Supreme Court 2 years ago in a case called West Virginia versus EPA. Congress gave us a preview of how they believe Congress needs to be prescriptive. It's a case that describes what we know as the Major Questions Doctrine. And in it, he says that departments and agencies have to have clear authority to be able to promulgate regulations that's given by Congress. We cannot promulgate regulation that may have economic or political significance, right? So we can't allow departments and agencies, according to the Supreme Court, according to this 2022 case, to go beyond the boundaries of what Congress intended. So when the case that overturned Chevron says that we need clear designation from Congress to the agencies, the 2022 case that talked about major questions was very clear, and that delegation has to be given when there are potentially economic or politically significant regulations that could be passed. Right? So that gives us a sense of what Congress is concerned about. And in that major questions case, Congress went further, not Congress, the court went further and said the words in the statute that we're interpreting now under this Major Questions Doctrine in 2022 was authorizing the Environmental Protection Agency to come up with the best system for emissions reduction. So this was another environmental case. The thing that I'm deeply concerned about is that in that case, the court decided that the word system was merely an empty vessel and did not have much meaning in the context of that statute.
Gotcha.
And we're dealing with digital ecosystems.
Mm-hmm. So just to go back to something you said in terms of kind of the knowledge set of Congress and the Judiciary, are you comfortable kind of characterizing where you think they are right now and how much work there is to be done in that respect?
Yeah, I think our members members and senators are very eager to regulate. I think industry. I've heard a lot of feedback that industry recognizes that it needs to be regulated in certain ways, and now the judiciary has a role in this space. So there's a lot of eagerness. There's a lot of willingness. There isn't as robust of expertise in Congress right now that that is going to be able to allow for prescriptive legislation to be passed in a timely manner to keep up with the national security threats that we are all facing in this digital ecosystem. That's the challenge that I think we are facing.
Right. So the point you just made about industry wanting more regulation, it sounds kind of counterintuitive to what we've been hearing all along from security leaders. They don't want prescriptive advice from government, et cetera. Just maybe if you could expand on that a little bit.
Yeah. So listen, I was a part of the Office of the National Cyber Director that crafted the President's National Cybersecurity Strategy. It was a whole of nation strategy. And in the process of making it a whole of nation strategy, we talked to the Chamber of Commerce, we talked to the large enterprises, we talked to the small and medium businesses, academics, and they all came to the same conclusion, and maybe different levels of it, but same conclusion that we know there's just so far market forces can take us. We've gone as far as we can. Maybe there's a little more we can do, but really now in that last mile, we need government regulation. I mean, even Brad Smith wrote it in his book, Tools and Weapons, that cloud service providers need to be regulated.
Right.
And I've heard that across industry. So that is real. That's true. I believe that, given what I've heard from industry. But pair that with what the courts are saying now in terms of who's responsible for that kind of work, anything that has an economic or political significance, and regulating, the automotive industry or the energy industry. Those have economic and political significance. That is within the purview of Congress now, according to the courts.
Right. So it's not just a matter of you've had your chance kind of thing.
Right, exactly.
What are some potential impacts to organizations, enterprises that may not be so obvious, like around either risk management or compliance efforts, things like that?
So I think there's going to be a period of time when there's going to be a little confusion about, who can regulate and how far the regulation can go. So my prediction, and take it for what it's worth, it's just my prediction, is that as a result of these court cases, we're going to see a lot of challenges to any new rules or even some recently passed rules. We're going to see a lot of legal challenges to that. We're going to see the courts struggling with those legal challenges and coming up with a rational interpretation of Congress's intent. It's incumbent upon us to educate the judiciary and members and senators and their staff so that they're able to then follow what's now the canon of statutory construction, which is that Congress has to be more direct and more prescriptive, and that the judiciary's role is to interpret Congress's intent more so than it is the executive branch agencies.
And would that fall on an entity like CISA or the FTC that obviously oversees a lot of cyber?
Yeah, so I think it's incumbent now, even more so than ever, for industry to be a part of this process. CISA, the FTC, all the independent regulatory bodies, and CISA is not necessarily regulated, but Health and Human Services or Department of Treasury or name them. It's all an alphabet soup. They all have to be very careful. I think we're going to see three things. I think we're going to see regulatory bodies being extra careful and more risk averse in how they promulgate regulation. Right? They no longer have the benefit of Chevron deference. So they will have to interpret whatever Congress passed in the narrowest way possible, in my opinion. I think we're going to see a logjam of legislation coming through Congress, and we're going to have to see Congress passing bills that are technical in nature, and that's going to take some time. Congress does not move at the speed of technology.
Sure.
It's just a fact, and the judiciary moves even slower than the speed of technology.
That's a great point. Like, how prescriptive do you imagine future legislation being?
Well, I mean, if taking a close look at that Major Questions Doctrine case, which is not a cyber case, but it's a heavily regulated industry, right? How we produce electricity, whether we use coal or natural gas to produce electricity. EPA regulates emissions, and it's very technical. And I looked at how the court looked at it. Mm-hmm. Congress put words on, in a statute that talks about the best system for emissions reduction. The court decided that the word system in that context was just an empty vessel, and that the Environmental Protection Agency only had a narrow role in reducing emissions in coal-fired plants, not necessarily. This is all getting very wonky, I know, but not necessarily, looking at the whole system and with coal-fired versus natural gas and et cetera. So I think that's going to be a challenge for us, because when we talk about cybersecurity, we're really talking about a system, right? And departments and agencies have to work within a system. Industry has to work within a system. And I'm talking, our digital system, our tech stack is a system. So you can't just regulate a little piece of it. You have to look at the broad implications. And I think we're going to have some challenges in helping Congress find the right words to legislate that way, right? I think that's going to be a challenge.
So just as a last question, last thought, you see any positives coming out of this? I mean, in adversity, there's opportunity. I mean, anything you can point to in that direction? I'm glad you asked that question, because very few people ask, what's the upside? Sure. Perhaps for me, the upside is maybe we elect more members and senators who have a technical background. There are a couple that are there. Some of our champions have now retired or left, but maybe there's an uptick now, of judges who will be appointed who have a technical background, and members or parts of our legislature at the state level and at the federal level who have a technical background. That can't be bad from my point of view, because I think every person, every human that relies on our digital infrastructure, and that has to have some level of understanding of that infrastructure. So that's not a bad thing.